So you are being told by your attorney that you have to go to mediation. What is mediation and what are the various roles? That's the topic of today's video. Hi, my name is Sean Palmer with the Palmer Law Firm, and I've been practicing family law as an exclusive field within the great state of Texas for the last 20 years. And you may need to have to go to mediation. What is mediation? Sometimes called assisted negotiation. The parties may participate in mediation voluntarily or by order to do so by the court. In this process, a neutral third person called the mediator facilitates discussion of issues and negotiation between the parties and their attorneys. The mediator is usually trained in the field of mediation with a minimum of 40 hours of classroom training. The selection of the mediator and the right mediator is critical to the chances of settlement through the mediation process. Good mediators have strong communication skills and ideally have relevant subject matter expertise in fields such as family law. What value does a mediator bring? Well, a mediator's task is to overcome the barriers that prevent parties from reaching a settlement. Mediators focus on resolving issues rather than winning or losing. The mediator acts as a buffer between the parties, moderating or eliminating many of the hardball tactics often used in the litigation process. The mediator accomplishes this buffer by translating the information exchanged by the parties and then reframing them to remove threats or ultimatums. Second, the mediator tries to understand what's motivating each of the parties and discover what each party really hopes to achieve. Third, the mediator uses information to try to help the parties generate options for settlement. And then finally, the mediator works with the parties to build and use those options by exchanging proposals and information to generate movement towards a resolution. During the process, the mediator relays information to each party, allowing the parties to find an acceptable solution. Mediation works because each side feels it's safe to reveal their concerns, objectives, and supporting information with the knowledge that the mediator will not disclose information to the other side without permission. Lawyers will control many of the aspects of mediation, including scheduling, location, and selection of the mediator. Your attorney will brief you about the process, help you define issues and goals for the mediation, and act as a consultant before and after the sessions. Your attorney will also review any draft agreements from the mediation before they're executed. Management of the mechanics of the process is largely relinquished to the mediator. The attorney's role is different from the mediator's in the sense that an attorney has an ethical duty to advocate for the client and obtain the most favorable settlement possible. The mediator, on the other hand, is impartial and doesn't take a position on either side, and his sole focus is to broker a deal. Given these differences, the roles of the mediator and the attorney may seem to be working at cross purposes during the mediation. In a sense, your role is to mediate between those two players and select an agreement between the two extremes they each represent. The lawyer, who's trying to get you the best deal that is one-sided in your favor, and the mediator, who's trying to get any deal at all, no matter whether it favors your goals or not. Ultimately, it's the parties who control the eventual outcome in terms of designing a settlement or deciding that they are not going to be able to reach an agreement and must take the matter up with court. Therefore, the success of mediation, to a considerable extent, extends not only to the skill of the mediator, but also to the party's willingness to enter the process equally empowered and prepared to respect each other's positional strength, to openly share information without fear, and negotiate reasonably and in good faith. As a result of these important requirements, most attorneys and mediators don't consider mediation a workable option when there's a continuing history of concealing or destroying assets and/or abuse between the parties. However, the decision to attend mediation at all may not be up to you. Many courts mandate mediation at various points in your divorce case, and if the court orders mediation, then you may have to at least attend the session and try your best. But with the help of your attorney, in most cases, mediation is successful in resolving many, if not all, the issues before you have to resort to trial. I hope this video has been helpful. My name is Sean Palmer with the Palmer Law Firm, where we can't protect your heart, but we can protect your rights.